Hello, everybody. Thank you so much for joining us today. My name is Tina Andrews. I'm with the Parent Information Center of Delaware, and we are very excited to bring you this series of webinars about the Return to School Roadmap from the Department of Education. Today's webinar is going to focus on Part B and Child Find. Our next one will focus on Part B and IEP development. And then our third one this month in January will focus on, we'll focus on Part C. I'm excited to introduce Stephanie Ramirez from the Disabilities Law Program at CLASI. She is going to guide us through this presentation. There is a lot of information, so we ask that if you have any questions, please feel free to use the chat and to raise your hands. We will try to answer questions throughout, but we might have to wait until the end depending on how much time it takes, because there's a lot of information we want to get through in this hour. If you have any questions, our information will be on the last slide, I believe. Our contact information, please feel free to contact us through email, phone, through our websites, and we can one-on-one sit down and talk with you about your concerns or your questions. All right, so as we said, this is a partnership between the Disabilities Law Program and the Parent Information Center. The Parent Information Center has been in Delaware for 38 years now. We work throughout the state in assisting families in advocacy and in making sure that their children receive the best education and receive a free and appropriate public education from birth all the way through transition. And we partner with the Disabilities Law Program. And Stephanie, you want to talk about that program?
Sure, and I think our information and stuff is on the next slide after this one. So the disabilities, I'm Stephanie Ramirez. I'm a law clerk with the Disabilities Law Program of the Community Legal Aid Society. The Disabilities Law Program and CLASI serve as the protection and advocacy system for the state of Delaware. What that means is that we're designated by the governor to provide advocacy for individuals with disabilities within the state of Delaware. We provide free legal services, civil legal services to underserved and underserved Delawareans and Delawareans with disabilities. And that comes in the form of individual advocacy. So on a case-by-case basis, we look at systemic advocacy where if it's a big issue affecting a big group of people, we can engage in that sort of assistance. And then we also do provide information, referrals, and technical assistance for other things that come up. So this is the Return to School Roadmap website, which is kind of accompanies the guidance. And I'm gonna let Tina kind of talk about this website.
Yes, so this website, the post on this website begin in August, and there are different areas of the roadmap. So we are highlighting all of the areas in this series of the webinars, but you can and should go to this email and look at the actual document, and it is for everyone involved in education. So that includes educators, school leaders, parents, families, and communities. And the goal of this, and we took this right from the site, the landmark number 1 is to prioritize the health and safety of students, school personnel, and families. Landmark 2 is to build school communities and support students' social, emotional, and mental health. And then 3, accelerate academic achievement. So as we talked about today, we're going to focus on Part B, but then at the end of January, so January 27th, we will focus on Part C as well.
And so in terms of these guidance documents, the U.S. Department of Education provided these guidance documents. The one that we're going to be talking about today is the first one under Part B, which is child fine. And that was published on August 24th of 2021. It's these guidance documents are supposed to help families, schools, everybody kind of get back to school, return to school. And so we're going to look at child fine today. Development and implementation of IEPs was published in September of last year, at the end of September. And then, like Tina said, Part C, we're going to cover on the 27th. And we're going to cover both documents in that session. So I wanted to do a quick overview of Part B of the IDEA, which is the Individuals with Disabilities Education Act. And that's the federal law that provides for special education. And I put the statute and the regulations on the screen. It's many hundreds of pages of stuff, but they're there just for you to have. And then Delaware has its own equivalent law, which is exceptional children. And I have those down there as well. So there's a statute, the law that goes along with it, and then the regulations or the rules that you follow that go along with that. So Part B of the IDEA covers children with disabilities aged 3 to 21 inclusive, which means are arguably up until 22. And generally what that means is that children with disabilities who are eligible for it can get services through this through the end of the school year in which they turn 21, or when they get a high school diploma, or they age out. The purpose of the IDEA is to make sure that children have a free, appropriate public education. And it's a very specialized term. It's called FAPE. And what that means is that it should be they should have special education and related services that meet their unique needs and prepares them for further education, employment, and independent living. And in terms of like their unique needs, what we always say is that the IDEA ensures that the child has an individualized program. So it needs to meet where they're at and what their unique needs are, because every child is different. And every child has their own needs and their own services that would be helpful to them. And then IDEA is also there to protect the rights of children and parents. There's a section of the IDEA that's the procedural safeguards that goes through all the procedures that protect the rights of children and parents and give parents and children rights under the law. It also helps schools and the government educate all children with disabilities and make sure that the education that the child is receiving is in fact effective. So the IDEA, like I said, it's big, there's a lot of stuff. It's got 8 different subparts. What we are mainly focused on is subpart D and subpart E. So D has the evaluations, eligibility determinations, IEPs, placements, all of that. And then subpart E is the procedural safeguards. And so child find is going to be under that subpart D. All right, so now we're getting into the actual guidance that was provided by the U.S. Department of Education. And so it's a particular document that I will link, and it includes a discussion of meeting timelines, ensuring implementation of initial evaluations and reevaluations, determining eligibility. And one of the most important things is that regardless of the COVID-19 pandemic or how children are being instructed, whether it's in-person instruction or remote or otherwise, children with disabilities are still entitled to FAPE, to that free appropriate public education. The fact that there is a pandemic happening does not mean that children then lose that right to that education. So the guidance itself is broken up into three different parts: the general child find requirements, referrals and initial evaluations, and child find considerations related to COVID-19. Before I get into kind of the meat and potatoes of it, one of the things I did want to mention is that there are some examples in here, and I had mentioned earlier, right, it's all individualized. So some of these examples may spark in you like, oh, that's exactly what's happening. And, you know, for my child, just everything is individualized, and every child, right, needs certain things. So these are just examples. There's, you know, there's always exceptions in certain cases. So if you do need or believe that one of these fits you, I would make sure to talk with PIC or with us or someone else, just to, you know, make sure that there's nothing else going on. All right, so what exactly is child find? So child find, and I have a whole bunch of words on here, but basically what child find is it requires the schools and the districts to actually find kids who have disabilities that would require specialized services. And it's to children who are living in their area or in their district. And there are some caveats to that. There are some instances where that's not necessarily the case. And we'll talk about one in an example in the next slide. But it applies to a whole host of children, including children who are homeless, and that's under the McKinney-Vento. Children who are wards of the state, so those who are in foster care, who are served by the DSCYF, the Department of Services for Children, Youth, and Their Families, English language learners, children with complex medical needs who are in nursing homes, and it also applies to individuals who are in correctional facilities. So there's because the IDEA goes up through 21 and including 21, the age of 21, it covers those individuals who are under the Department of Corrections. And there's special rules that go along with that, but just know it does cover all the way up. So here's an example. So Lewis lives and attends a private school in the Red Clay Consolidated School District. His mother believes that he may need special education and related services, so she requests that an evaluation be conducted to determine his eligibility under the IDEA. That request and the obligation lie with the Red Clay Consolidated School District as the LEA. So it's not the private school that would be required to evaluate and do all of that. It's the public school. It's that it's the school district that's required to find Lewis and identify him or not as a child who would be eligible for services under the IDEA. And so there's a little note off to the side. So if, and this is all assuming, right, that the private school is located in the bounds of the Red Clay, of Red Clay. If that private school was outside of Red Clay, then the district where that private school is located would then be responsible for identifying and evaluating Lewis to see whether or not he would be eligible for services. So who can actually refer a child to determine their eligibility? Anybody. Anybody who believes that the child's eligible. And it's mainly going to be either the parent, the teacher, or the healthcare provider. But only the parent or the LEA, the local education agency, which would be the district, or the school, right? Only they can actually start the request. So they can be referred. A pediatrician could make a referral to say, hey, I think, Lewis might need special education and related services, but only if the parent or the school or district say, hey, I'd like to get, Lewis evaluated for services, would that request actually be made? And so then the question is, well, once a request is made by the parent or the school or district, do they actually have to do an evaluation? And that answer is no, they don't actually have to. But if they don't do the evaluation, they have to provide prior written notice explaining that reason, explaining the reason they're not going to do it. Normally, prior written notice is a standard form that has a whole bunch of different areas. And one of the things is, what was proposed and then why it was denied. So they would have to explain why they're actually denying that request. And then if the parent disagrees with that denial, if the parent says, no, I really think that Lewis needs to be evaluated, I really think he would qualify for services, then what that parent would do is then file a state complaint or a due process hearing. And those are under those procedural safeguards. And a state complaint has to be filed within a year from whenever that denial was. And then due process, file for due process hearing would be 2 years. And I think there's information about that on the next slide. So examples, 2 separate, one yes, one no. So we're back with Lewis. So Red Clay received the formal request for the evaluation from Lewis's mom. So we're good, right? The mom, the parent, is the one requesting the evaluation. So on the left side, Red Clay decided, nah, we're not going to do the evaluation. And they send the proper notice, right? They did a prior written notice. They said, we're not going to do this evaluation because XYZ. So then Lewis's mom would have 1 year to file a state complaint, or 2 years to file for a due process hearing to challenge the denial of that request. And the Department of Education the Delaware Department of Education on their website has all the information. I think they've got like draft state complaint forms and also draft due process forms. And also as parents of children with disabilities who qualify under IDEA, they're provided with procedural safeguards, which is I don't know, several page booklet that explains all of your rights under the IDEA. So then on the right side, Red Clay receives it, and then they decide, you know, we agree, Mom. You know, we think that Lewis may be a child with disability, and may be eligible for special education and related services. So what they then do is they send a permission to evaluate to get informed parental consent. They're at this point, there's no time frame where the school needs to send the permission to evaluate. Typically, they'll try, you know, have a conversation with the parent to determine whether or not the parent actually wants the evaluation. And after that, they may or may not send the permission to evaluate. But then once they get that permission to evaluate back, then there's a timeline for when they need to actually conduct the evaluation. So once Lewis's mom received the permission to evaluate, signs it, sends it back to the school then has 45 school days or 90 calendar days, whichever is less, to do the evaluation and to hold a meeting to determine the eligibility. So whichever is less. So if it's over the summer, right, it would be probably the 90 calendar days, which would be less, but it really all depends. And then there's a whole host of requirements that go into what the evaluation actually must include. And all of that is in the IDEA and in the in Delaware's exceptional children law. And it includes, information from the parent guardian, different kind of assessment procedures. And they can't use any one thing to determine whether or not the child would be eligible for special education and related services. And we're going to talk a little bit more about that in the coming slides. So with the state of things now, with the pandemic still raging on, and I think there was a Delaware online article yesterday or the day before talking about, a lot of school districts here in Delaware are going remote, whether partially or they've been remote for a week already. Hopefully we can get back to in-person more so. But what this remote learning does is it presents some unique challenges for actually doing child finds, because it's limiting face-to-face interactions and in-person contacts with teachers or other school staff. So what this is, normally if the child is at school, teachers and other staff, whether it's paraprofessionals or counselors, librarians, anybody might see things that could lead them to think, oh, well, this, child might need special education and related services. Without being in person, it's hampering that, right? They're not able to do that as effectively because the only way that they're seeing these children are through Zoom or other means. And so it's much harder then to conduct effectively these child find activities. So additional considerations must be taken to ensure current child find procedures are effective. So the school district cannot rely solely on referrals by parents in meeting their child find obligations. They are still required to actively find those kids who may qualify for special education and related services. And I didn't put it in here, but the guidance for Child Find under Part B actually has several sections on what those activities could be, whether that's a home visits to visit parents and kids and do some Child Find activity that way. It has a whole host of them. And my assumption is that, the schools and school districts are aware of this guidance and have hopefully have been using some of those additional Child Find activities that, are kind of necessitated and needed because of this pandemic. So should a student who made little academic progress because of educational disruptions caused by COVID-19 be referred for an evaluation to determine eligibility for special education or related services? So basically, should any child who didn't really make a lot of progress be considered for special education services? And a lawyer's favorite answer, right? It depends, or not necessarily. And that's exactly the case here. So every child who is making little academic progress is not necessarily making little academic progress because of a disability or otherwise. So what Child Find is there to do is to find children with disabilities whose disabilities are adversely impacting their ability to participate in the general education curriculum, right? So their disability is making it difficult for them to participate in school one way or the other. And so here, if it's just an educational disruption because the school shut down for a week because of COVID, or when we were going through everything in March of 2020, March of 2020, when things were initially shutting down, not every student who made little academic progress for those couple of months would necessarily need to be referred for an evaluation, because even if that child did or did not have a disability but doesn't qualify under IDEA yet, that educational disruption was the cause of them not making progress rather than their disability. And under the IDEA and under Delaware's exceptional children, right, the main factor in determining eligibility may not be limited instruction in reading or math. So if a child is not receiving adequate reading instruction or math instruction because of disruptions, either because of quarantining or because of staff shortages that are, that schools are needing to shut down or go remote or something, that even if they're referred for an evaluation, if that's the main reason why they're not making that academic progress, it's they can't be found to have to qualify for services under the IDEA if that's, the main reason. But the district and school should still work with the parent to identify some additional supports and interventions that student might find helpful or might need in order to actually make that academic progress. So here's an example of that. So Evelyn attends a school in the Seaford School District. Because of the COVID-19 pandemic, quarantining happened, remote instruction happened, everything happened. And so she didn't get adequate instruction and then failed to progress academically. But she is not otherwise suspected of being a child with a disability. So the parents, pediatrician, school doesn't think she actually has a disability. She just didn't make academic progress. So the school declines to conduct an initial evaluation. And of course, in doing that, they provided prior written notice, letting the parent know, I'm denying this I'm denying this request for the evaluation. But they do agree to provide general education support, such as after-school group tutoring, to meet Evelyn's needs. So this is a kind of an intervention that all students at the school are able to get because of this limited academic progress. And so the school can provide that, and that's okay. But the school's not going to necessarily want to do that evaluation because, she's not otherwise suspected of having a disability. It's just because of COVID and everything that's happened, she's not making academic progress. And I believe under the federal money that was provided to the Delaware Department of Education, and then that came down to the districts and everything under the American Rescue Plan Act, and then some other money, the schools and districts can use that money to provide some of these services. But it's all up to the district on how they want to use that money. And I believe their plans are posted on the Delaware Department of Education website.
So, and can I just say that as a parent, you may be looking at this and it might be confusing, or you might not at this point know if your child, if there is a potential disability that's causing the, regression or the, them not to progress academically. And, definitely we have parent consultants that you could talk to. Definitely, there are developmental pediatricians and other professionals that can work with you to kind of assess where your child is and what supports they might need, and help you communicate that to the school.
Thank you, Tina. And I went ahead and put in the link to the guidance that we're going through here. A lot of the questions are kind of taken straight from that. And I added some of the examples, but one of the things that I really like about how the U.S. Department of Education does their guidance is it's very user-friendly, very parent-friendly, and it's all in Q&A format. So it's question and answer, and it's really helpful and kind of breaks everything down, and also provides you with the citations to the regulations and the law when that's needed and necessary. So we'll continue with COVID-19 and some of the issues. So what if a child has symptoms from COVID-19 or long COVID that adversely impacts the child's ability to participate in the general education classroom? So if that child is experiencing symptoms and is therefore suspected of having a disability, and the federal government has since said that long COVID is considered to be a disability under the ADA, the Americans with Disabilities Act, as well as could be considered a disability right under the Individuals with Disabilities Education Act, or the IDEA. It would, if there are symptoms from that that are then impacting the child's ability to participate, then they should be referred, and actually not should, they must be referred for an initial evaluation. And that's language taken directly from the federal government. They must be referred for an initial evaluation. And so the example kind of includes some of those symptoms from long COVID. So Samantha got COVID-19 during the summer of 2020. So right after school shut down, yeah, it had come. So when she went back to school in fall of 2020, and we were all remote at this time, right? But she felt more fatigued. She was tired. She was having difficulty concentrating. Her participation in class declined along with her grades. So the school or the parent or guardian should request an initial evaluation to determine whether or not she would be eligible for special education and related services. So I'm hoping that you can kind of see the difference between this example and Evelyn, right? Where Evelyn didn't make academic progress because of she wasn't getting just adequate instruction. In this case, Samantha's not making adequate progress because she has long COVID and it's impacting her ability to concentrate, to think, to participate, and she's feeling more tired. So if all of those symptoms from long COVID are impacting her ability to participate, then she must be referred for an initial evaluation to determine whether or not she would qualify and be eligible for special education and related services. So this is kind of beyond the guidance. If you feel like your child's rights have been violated, there are several different options and several different ways you can address that. I believe the majority of these are in the procedural safeguards. If we take, right, so we talked about Lewis. Lewis's mom wanted an initial evaluation. Red Clay said no. So what could Lewis's mom do? Well, Lewis's mom could file a state complaint. As you know, as I had mentioned, the state complaint, you have a year from that denial or from, whatever violation there was to file the state complaint. And that goes directly to the Department of Education. And they have all of that information on their website. Lewis's mom could file a due process complaint, which is 2 years from that date. And due process complaints and state complaints, they both try to do mediation, usually through Spark. And I cannot ever remember what Spark stands for. But Spark is, Tina probably knows.
Put me on the spot here.
So like special.
Yeah.
So Spark is through the Biden School of Public Policy at the University of Delaware. And they provide the mediation services for the Department of Ed, the Delaware Department of Education. And typically for the state complaints, due process complaints, they'll usually the Department of Education will send the general information over to Spark to reach out to see whether or not, thank you, Midra and Carrie, the Special Education Partnership for the Amicable Resolution of Conflicts.
Thank you.
Yes. So they'll try to send that over to reach out to the parent and to see if the parent or guardian is interested in going through mediation. And mediation, they have an independent mediator who will sit down if both the parent and the district agree to the mediation to try and resolve the conflict. If it's unable to be resolved, at least with the due process complaint, then it goes to a hearing. And I mean, we could probably have a whole separate presentation on the complaints and everything.
And so let me just jump right in there. We do have webinars in our video portal. We partnered with Spark a number of years. And so those videos are available if you would like to learn more about mediation, also about state complaints and due process. That information is there.
Thank you for that. Yes, due process complaints are basically like hearings in front of a panel, and you present your evidence and the district presents their evidence, and it's the whole thing. The state complaint is basically an investigation that a independent investigator does that's contracted with the Department of Education. And they have, I believe, 45 days to complete their investigation. So typically, if mediation can't be completed in that 45 days, the investigation just continues. You can also just request mediation on your own. You don't actually have to, request or file a state complaint or due process complaint to get to mediation. You can just send the request, the mediation request outright before doing all of the other things.
And Spark also will do facilitated IEP meetings if you feel like you need that. They have a brochure that talks about all of their processes and has their information. They have it on their website, but we also can get that information to you if you are interested in exploring that.
And then the other two are federal options. There's the U.S. Department of Education Office for Civil Rights. You can file a complaint with them. They are, I would say, horribly under-resourced and staffed. And even if there is merit or like there's evidence that something happened, it doesn't necessarily mean that they are going to investigate and do anything. It's all based on their resources and kind of what the priorities of the current administration is. Under President Trump, the priorities for the U.S. Department of Education's Office for Civil Rights looked very different than what they were under President Obama or what they are now under President Biden. And then the second option is OSEP, which is the Office for Special Education. It's the U.S. Department of Education's Office for Special Education Programs. And there's ways through them that you can also kind of make reports of issues that are kind of going on. And as always, you should feel free to visit PIC's website. I've been on there and have definitely seen and used many resources that they have. And you can also, our website, the Disabilities Law Program, has several resources as well. You can also contact us for individual questions. Thank you, Maria. 60 days, not 45 for the investigation. Too many timelines. So state complaints, the investigation has to be done within 60 days. And I believe there are definitely options to extend. There have been like requests made to like extend the investigation for like exceptional circumstances like the pandemic. That might make things a little bit more difficult. But it's exceptional circumstances, not, we're just going to extend it. And then if you need help or have questions, here is DLP's information, PIC's information. And as I mentioned earlier, this presentation is general information. Not intended to be legal advice. I am from a civil legal services organization. I'm not providing legal advice here, just providing information, general information. And then for questions that are specific to your situation, you should feel free to contact PIC or the Disabilities Law Program.
Yes, and if you have any questions, please feel free to put it in the chat or to raise your hand, and we will ask. As we said, if there is a private matter or if you have a personal situation with your child or a grandchild, you know, feel free to contact us through the emails and phone numbers that are presented. Next week at the same time, same day, we will have a presentation. And do we have, I can't remember if it's on here. No, okay. We will have a presentation on Part B, IEP development and initiation, implementation, sorry, and the guidance on that section. And then the week following that will be focused on different parts of Part C. So hopefully you will join us then. You can register in the same way that you did today. And you can also send us questions or ask questions during the presentation. There will be a survey that goes out at the end of this call. Please fill out the survey so that we know if this information was useful, if there is something else that we can do or provide that will assist you more. And thank you to everyone that attended and listened. We really appreciate it. And have a great day.